Hello friends, in the series on the income tax cases, today we will discuss the case of Cherthala Taluk Agriculture Credit Cooperative Society versus Income Tax Officer and others. This case has been reported in 457 ITR at page number 727 and the matter has been decided by Kerala High Court and the date of the judgment is 28th November 2022. As all we know that in the assessment proceedings, when the assessment orders are passed by ignoring the judgments of the various courts and especially the Supreme Court, then what is the fate of those assessment orders? Generally, it is understood that when the assessment order is passed against the assessee, then the assessee has to go to the CIT appeal and then ITAT, High Court and Supreme Court. But in cases where the assessment orders are passed, especially ignoring the Supreme Court judgment, then there is a very important judgment of Calcutta High Court in the case of Poonjar Service Cooperative Bank Ltd versus ITO. In that case, the Calcutta High Court had said that when the assessment order is passed by ignoring the Supreme Court judgment, then in that case, if the assessee will be dragged to the route of CIT appeal or the alternative remedy, then in that case, that alternative remedy will not provide the true justice to the assessee. The crux of the theory is that in that case, the assessee has a right to directly go to the writ court and get its order quashed by the High Court. In the present case, the assessing officer denied the deduction under section 80 subsection P clause II to the assessee after the assessee has quoted the very two important judgments on the same issue, that is section 80P clause II clause D. One case was of Supreme Court and the second case was of Kerala High Court. The Supreme Court judgment is Mavilai Service Cooperative Bank Ltd versus CIT 2021. The citation of the judgment is 431 ITR page number 1 and the second judgment which is available on the same issue was of the Kerala High Court. The name of the case is Perur Kada Service Cooperative Bank Ltd. The citation is 442 ITR 141. In these two cases, the same issue was involved and the deduction under section 80 subsection P clause II clause D was allowed to the assessee. When the assessee filed the writ petition against the assessment order which has not given the deduction to the assessee under section 80P, it was the contention of the department that the income tax proceedings are based on facts. So the writ petition of the assessee should not be entertained because in writ petition, the court do not involve itself in the determination of the facts. The second plea of the department was that the assessee has alternative remedy of going into CIT appeal. But the main concept of going into the writ is that when the assessee has effective and efficacious remedy, alternative remedy, then assessee cannot go into the writ. So the question arises whether in the present case the assessee has available the effective and efficacious remedy. When the assessment order has been passed very badly by ignoring the decision of the Supreme Court, then it will be like disturbing the law which has been laid down by the Supreme Court. And the assessee has to fight its case for a long period of time. First of all, CIT appeal, then ITAT, High Court, Supreme Court, and in the meantime, the department also levies a number of penalties on the assessee. So, in that case, it cannot be said that the assessee has efficacious and effective remedy available against the assessment order when this assessment order is against the clear-cut Supreme Court judgment. The law has been laid down by the Honorable Calcutta High Court in the case of Poonjar Service Cooperative Bank Limited, where it has been categorically said by the court that if any assessment order is passed ignoring the Supreme Court judgment, that will be not treated as the effective remedy, and if the assessee will be dragged to the CIT appeal, then it will not be a justice to the assessee. Friends, this case is very important, especially in those cases where the assessment order has been passed by not following the Supreme Court judgment rulings, the ratio laid down in those judgments, so the assessee can go directly to the writ and get its order quashed from there. At the end of this video, once again I am repeating the name of the case. The name of the case is Cherthala Taluk Agriculture Credit Cooperative Society versus Income Tax Officer and others. And this case has been reported in 457 ITR page number 727. The matter has been decided by Honorable Kerala High Court and the date of the judgment is 28th November 2022. Thank you, friends.